Hello. Oh, excuse me. Hello, everybody. This has been the most technically difficult intro that we've had yet. Hello, everyone. Welcome to Bring the Jury. I'm here with Luke and Brian Sheely of the Sheely Law Firm here in South Carolina, offices in Charleston and Columbia. This is the Bring the Jury podcast where we talk about a wide variety of different cases happening across the nation. And today, for our season finale, we will be just chatting with these two guys about some of their own personal experiences, trial experiences, and cases that they've had over the last decade or so. So feel free to drop your questions as we kind of go along here, and I'll ask those live time.
This is one of those moments when our actual work life interferes with our podcasting life because we haven't had a chance to review certain cases that we might have been following because we're in the middle of preparing for our own murder case that starts in a week. So kind of been in the weeds. Sorry, everybody. But
I think this will be for a great episode.
No, it gives us more of an opportunity to do what we want to do anyway, which is talk about ourselves.
Yeah.
So that's great.
All right, so we're just going to start it off, kind of take us from the beginning. Talk about maybe your first case that you all tackled together, just a notable case kind of early in your career together.
Well, probably the first one we ever did together, and we're not going to use actual names of even former clients with cases long resolved, but was a case where the allegation was murder in a prison setting, and our client was already doing life for murder. And the case was one where he doesn't have a lot to lose. He won his trial. He denied it. But the allegation was that he shanked somebody over some money that may have been owed to him. And he was ID'd by a couple other inmates who, of course, are serving a lengthy sentence.
And he had nothing to lose, but he had some things in his mind to gain. I mean, it was in South Carolina, murder is a non-parolable offense. But how long had he already done in prison? His one was one of the older murder charges that still was eligible to possibly get parole.
Yeah, he had done probably like 20 years already, and then had this. The thing he was mostly concerned about was that he was in severe kind of lockdown based administratively on serving life for murder and getting a new pending murder in prison. So his life was very restricted. And, objectively, prior to being charged, he was really fit, spent a lot of time working on his physique.
Lifting boulders in the yard.
Yeah, literally like home workouts. Yeah. But when they took away all his privileges, he just stuck in a cell pretty much all day with very limited recreation. So he went from this kind of physically intimidating guy to then kind of this little shrunken version of himself, which really helped the way he presented to a jury.
The prison put him in what they call supermax, which is like lockdown in the prisons, and he would get like 1 hour of rec a day, which really wasn't even outside. He'd be in his cell all day.
Isn't that called like the queue? Or what's like the nickname for it? Is it the queue or?
Well, he would get to walk.
Or the shoe, right?
Well, that's special housing unit. That's something a little different. This is Supermax. And so he would get to walk around in like a 8x8 room.
The first time we ever met him, we had to go through like 10 concrete doors.
And then I remember we met him. Remember what he looked like?
Well, he was attached to a leash. And he had this shield over his face to make sure he wouldn't like spit or do anything
or bite or something.
It was very much kind of a Silence of the Lambs kind of thing. And so
we were younger lawyers back then. That made an impression on me.
Yes, it did. Although he never, I was like, all right. He never acted any kind of dangerous way towards us, but he was treated that way by the prison. But it was hard to have like a real private attorney-client meeting when he's attached to a leash, just kind of the door mostly closed.
Didn't we demand that they take the leash off at least while?
Yeah, I think they're like, your funeral, but but it was a whodunit case. Sammy wasn't pleading. I said his name, but he wasn't pleading anything.
So that was an ID case, identification.
And so you had two inmates identifying him, but there wasn't any blood, There wasn't any evidence. They shook down his cell right afterwards, allegedly. They couldn't find the shanks. They couldn't find anything. And he's like, I don't know what you're talking about.
His cell was as neat and tidy and clean. He had all these sneakers lined up, all perfectly white. And there's no blood spatter. There's nothing.
And now when they did search, they found like 10 shanks. And so I remember the prosecutor, was a young prosecutor, one of them, and he put all his shanks up next to one of the testifying witnesses who was doing like life or rape or something terrible, and then just put him like within arm's distance of the witness, and we were like, and I remember the lead investigator talked about suitcasing things, which is basically like, you know, moving shanks in and out of facilities in your own internal suitcase.
So they turn over this dorm. They shake it down instantly, and they're looking at everyone's rooms, and they find 10 shanks in the dorm. And this was an AIDS dorm. This was a segregated dorm in the Department of Corrections. So that's the other part of the setting
where people have HIV. They segregate them at that time.
And our client, you know, when he caught the murder bid and he was doing life, he didn't have HIV. But this was such an old school environment back in the day. They actually used to have, and we learned this from working the case in the prison system, they used to have conjugal visits with the inmates where they could have people come and have
relations.
Congress, right? And so he caught AIDS from one of these visitors that he was allowed to have serving his sentence. So, but they, you know, do they still have an AIDS dorm?
I don't think so.
And that even
I think that's frowned upon. But
that was what he was.
But Sammy was not the type of guy that could ever testify in his own defense. But he basically shrank up into a little tiny old man.
And you guys threw the sweater on him.
And we appearances matter. So
that was the beginning of the Charlie Brown defense.
So we figured, well, they don't. They're going to talk about him being in prison. We need to make him look cuddly, soft, approachable, and so we put him in like a Charlie Brown sweater, and he had
the muzzle.
He had these he had these broken glasses, and he just read his Bible and kind of did this number throughout the whole trial.
I was sitting next to him, and he would say unintelligible things nonstop,
right,
kind of under his breath.
But what we came to learn was he had a lot of real influence in that particular dorm. And so as we got to the trial, I think O'Brien discovered that the room that they were 100% identifying as his cell had lockers in them with numbers. And we realized kind of towards the end of the middle of the trial that they had searched the wrong room.
What we discovered through investigation, and this was toward like the last day of trial, or close to the last day of trial, as we were trying to figure all this out. Because, we liked it that our client's dorm or his cell was pristine. That was good. There was information that, like, he did this because there was a cart runner that was running drugs that didn't either got on his territory or didn't pay him or something. So that was bad. And the fact that he was doing life in prison for murder, that was bad.
He was ID'd.
And people were saying, our guy did it, but like there was no evidence. So, but I did determine towards the end of trial that that was not his room. That they had an evidence. So when this murder happened, SCDC has their own internal kind of like investigators that come rushing to investigate. And Sammy had such influence over the dorm. He had paid off guards.
Well, that was an assumption.
That was my assumption, to showcase some other dorm as the dorm that was his for evidentiary purposes.
So it was either wild incompetence or they searched the wrong room.
Yeah. So that was an interesting aspect. Another very interesting aspect to this case. I remember we had these witnesses and again, this was an AIDS dorm, so like these folks were not well. And I remember the state had one witness that I think we actually had to find it for the state because we thought he was somewhat beneficial to us, but like They brought him in a hospital gurney into the courtroom.
Yeah.
They like rolled him in, which was kind of unique trial dynamic. But yeah, so that case.
But it was not guilty. The state
Yeah, I was
failed.
gonna say,
The state
yeah.
failed to prove its burden beyond a reasonable doubt.
Right, and so we could not put up a case, so we didn't introduce any evidence. At that point, we had a client that was not able to assist us. I mean, our interactions with Sammy were kind of like, "Hey, you ready to go to trial?" And he was, "Yep." And you got anything you want to help us with? And he would smile, and he was.
I'm not pleading. I'm not pleading.
He was writing his notes, and I was next to him. And they looked like that. Like pens were disappearing off the table. Paper clips were getting suitcase various places. I have no idea, but when
It
you
would make for a good shank later.
and the other thing is you can't really prep a guy that's in Supermax. It's difficult because like physically they're not they're locked in a box for 23 hours a day, and it really was a case designed to make the state meet their burden. And I remember just us saying they haven't met their burden. There's no blood. There's no evidence. I remember our co-counsel at the time, who has he always likes to tell stories about himself in openings or closing, and I recall him talking about equating this to a pig hunt that he had done, and there was blood everywhere, and this would have been just like that, and it was a gory scene, but our guy's room was just completely clean, forensically clean, and so that's the way. I mean, was this guy guilty? I don't know, probably. But did the state meet their burden? No, they did not. And the jury didn't feel convinced about that. So that was the system working.
And he was very happy because he got out of his lockdown Supermax situation back to regular population, and he's still serving out his original life sentence. And so, no harm, no foul. But that was our first murder case together.
And it was a success.
Right.
There you go.
And we do things a lot differently than we did back then. But
Oh yeah, way different.
So, Luke, before we got on, you were talking about a case that you had involving a flight attendant. Is that right? Or what?
Well, yeah.
Okay.
That was a pretty high-profile case that I had when I was at the public defender's office, and then I would do the appeal in private practice. But it was an allegation of domestic argument with a guy who was dating this woman who was a very successful and attractive flight attendant who lived in Charlotte, and he lived in Columbia. And actually, they made a whole TV show on Oxygen Channel about it.
Oh.
It's called
Who plays you?
well, it's kind of cheesy.
A dirty criminal defense lawyer, or some
I think at the time,
shadowy figure.
I basically refused to be interviewed because I was doing the appeal at the time. But it's called like Chained Heat or Scorn something. But it was a pretty gruesome allegation where they claimed he killed this woman and then took her body to a different county in the trunk of her own car with the aid of another girlfriend, and then set it on fire, and then looted her bank account while calling numerous other girlfriends
That's a bad look.
on the ride home. And so it was a big investigation with multiple agencies from Charlotte, from here. And this guy had no record, was middle-aged, very well-spoken, and worked at a nuclear power plant, and was, very sympathetic generally, and said, look, our defense was self-defense, that she wanted more out of the relationship than he did, and that she attacked him with his own gun in his home, and the gun went off in a struggle, and then he basically panicked. So we had to kind of own the fact that during his panic, he made a terrible mistake and wrongly covered up evidence. And that was a case where we tested South Carolina's stand your ground laws before they were really even, until the ink was not even dry on the law practically. No one knew how to do them. And we ended up also really testing law enforcement's policies because they were attributing a lot of things to his confession that he said never happened. But the thing at that time, they didn't record their interactions with defendants, suspects.
What year was that, Luke, when that incident happened? Because now they always video record.
Well, they do it because of that case.
Right.
Because we made such a big deal of it.
What year was the incident?
I think it was like 2009, 2008.
Well, Luke, how are you able to make a big deal about the confession and their kind of accounting of it when it wasn't recorded? What did you do?
Well, obviously, he testified vastly differently to what they claimed he said. They claimed he said these very incriminating things, but it's not in a statement. And he's like, no, I didn't say that. And so he would detail kind of their techniques, which were very heavy-handed. But also, one of the investigators and I had a quite contentious moment because I was aware that this investigator did record some cases on occasion, but it was like with a childhood friend of his who got charged with murder, and when he investigated that guy, he actually did record it. And so I brought that up during our cross-examination to show his double standard and how he knew that recordings can protect people, and he's willing to do it for a friend but not for anybody else. And it became quite contentious, and I think
Is this the guy that threatened to fight you?
no, that was a different guy.
Okay, we'll get to that one
I've got a little plaque in my room. It became so contentious that we took a break, probably a court-enforced break, and one of the jurors was documented by the court reporter going, "This guy's an asshole." Right. I don't know if they're talking to me or about the investigator, but we ended up ultimately he was found not guilty of murder, but guilty of voluntary manslaughter, and so he got a much lesser sentence. And then I was so invested in that case, I took the case on appeal for 7 years.
Well, it had everything that you like. It had self-defense. It had kind of dealing with bad facts, the worst facts after a killing, like looting bank account, calling girlfriends, setting a car on fire. So that was a challenge. It had dealing with an area of law that I would have to say is now one of our favorite areas of law. Stand your ground, essentially codified self-defense, but for the duty to retreat. That case was that your first and only appellate foray?
Yeah. Court of Appeals twice, Supreme Court, and then I petitioned even for the United States Supreme Court, but they did not want to hear that case. I was heavily invested in it.
Yeah, that was a good one, but that was a little bittersweet.
And there is some made-for-TV Oxygen Channel series about it. It's called like Unchained or like Burning Fury or something.
Somebody wants to know, so did he take the money from her account?
Oh, yeah.
Oh, yeah. Okay, so that was confirmed.
Yeah, I mean, we had to kind of own those bad facts. I mean,
Okay.
he went right up to her ATM after the fact.
Oh.
He was never charged with that.
I mean, I think the defense was he was
He's distraught.
he was
He didn't know what to do, so he
No.
stole her money.
I think the defense was, it was self-defense, but he was an a-hole.
I mean, yeah. I mean, he was simultaneously. We had to live and really explore the concept that he was simultaneously dating like 8 women at once, but she was very much invested with him and like kind of got mad at him because he just wanted it to be very casual. And so that was what his testimony was, and that enraged her because she was looking for something more. But it was a missing persons case. I mean, they couldn't find her for like a month, and then they tracked her phone to his house. And so
That was the first. I think the first stand your ground case officially done in South Carolina after the act. I mean, I know there was Duncan, but Duncan kind of said we get an evidentiary hearing.
No, Duncan had not come out.
It had not.
I mean, it may have.
That's right.
The trial may have occurred, but Duncan had not come out as a case. But
Right.
Anyway, so that was wild. I still, check on him from time to time, and he's doing all right. But that was a tough one, very contentious. Obviously, from the state's perspective, we received, and it got at least regional media attention, but it was pretty high profile and high pressure.
So that was, I think, it certainly was the first standing ground in Richland County, maybe the first actual request for an evidentiary hearing in South Carolina.
Yeah.
So that was self-defense. We talked about Sammy as an ID case, identification. That's one good old way. I mean, it seems like a lot of our cases are self-defense. Where we're saying that someone was justified in doing what they're doing, but other defenses would be just like false confession, which is really tricky.
We've had one of those.
We've had a false confession case, so it's tough.
That was the young boy, or the younger.
Well, we've had a couple false confessions, but this one went to trial. And do we still have a PCR on that?
Mm-mm.
Well, this was a pretty infamous case because it was a killing of a mother on Mother's Day. And the state prosecuted the husband twice. And our client was a star witness. We talked about this one before?
I think so. And it was like his friend or something?
Yeah, our guy was kind of like the nerdy hang-around friend, a little weird, but generally friends with them. And he claimed to witness this fight between husband and wife where this stabbing occurred, and the husband is objectively doing things to get the suspicion of law enforcement, like taking the wife and pretty much dumping her body, literally throwing it like in the side of the ER out of his van and saying like, bitch bled all over my van and stuff like that, and he was out cheating on
Language, Luke.
Sorry. And he was out cheating on Mother's Day. That was in the record. So the state liked those facts a lot and thought the cheating would be good motive for he and the wife to get in an argument. And our client was their star witness for 2 trials, and then finally the guy was acquitted. And so then the state decided, well, we want to take a harder look at this. Let's get some fresh eyes on it. And by that time, our guy had moved out to California, and they re-examined a shirt that the victim was wearing, and they tested a new part of it, and lo and behold, they claim it had our guy's blood on it. Now, our guy's blood was always on the scene because he claimed originally in the first 2 trials that he was hanging out earlier and he cut his hand on an apple. So he just happened to bleed. So they're always, in retrospect, as we looked at this, we were always like, if I wasn't the guy's lawyer, I would say, hey, cops, you were so just invested in prosecuting the husband, because that's always where you look, that you ignored just like obvious evidence. Our client had given basically 8 different statements explaining his blood and everything else. So those prior trials and the apple, and now his blood on her shirt, which would be, it's different to leave your blood in the kitchen as you're cutting apple, but to have it on her shirt, that they were like, okay, we need to go talk to him. And so they tracked him down all the way out in California and confronted him with this and put him on a polygraph. And a polygraph is a very serious interrogation tool. It's not admissible in a court of law, but when you put someone on a polygraph and you tell them they failed and they better come clean because the machine is saying you're a liar, that can make a lot of people tell you things. And our client ultimately confessed in California to killing her because he made a move on her and she rebuked it, and he was like, well, your husband's out cheating on you now anyway, and they got in a scuffle where she got stabbed. And so that is how the case came to us. So it was an interesting trial in the fact that our best defense ended up being re-prosecuting the husband, because that's what, if it was good enough for the state of South Carolina for 2 different cases,
I mean, that would have to be a reasonable doubt, right?
Right, you would think. And so it was a very tough one. All these law enforcement officers were pretty conflicted because
careers were being ended in that case because the new theory of prosecution was we got it wrong the first 2 times.
Sorry,
And
our bad.
The lead investigator was like kind of thrown to the wolves, and he was sticking to his guns. I mean, that was an interesting cross that I got to do, where he was like basically agreeing with me that he still believed the husband did it. He believed his investigation was the best investigation possible, and he got him to admit, I still believe the husband did it. And that should normally be enough reasonable doubt,
Right.
but our guy confessed.
Our guy did confess, and we had to treat the case for various reasons. Various offers were turned down, offers probably in hindsight that he should have taken. And he insisted on saying, well, that was a false confession. I didn't do this. It's just like I always told police. And so we spent a lot of time trying to educate the jury on how confessions can be falsely coerced from somebody when they feel it's kind of like a bear or with its foot in a trap. I mean, an animal trapped like that would rather chew its own leg off and hurt itself severely, but it'll do that to get out of the trap. So that's the idea, that you incriminate yourself, hurting yourself severely, but you think you've gotten out of the trap. So we did spend a lot of time and energy with a good expert trying to educate the jury on how that can occur, but just simply they didn't buy it, and they took his confession and his own testimony was not.
Ooh, it was a video confession too.
It was a video confession.
Oh man.
Pretty compelling, and he went down on murder, and so that was a tough one. We did end up making some law about areas of what police are allowed to say and how forthright they have to be to a judge when it comes to getting a warrant, because we had an issue in that case where we didn't feel that those officers, when they were getting our client's warrant, they failed to kind of mention all the history of the case before them, and that a judge, having had that full picture, probably would have felt that they couldn't get the warrant or needed more information. So they kind of left out all that stuff that would tend to exculpate our client, which is the fact that they spent 2 trials prosecuting the other guy. So that did make a little footnote of legal history, but unfortunately our client went down on that one.
Yeah, and we have a reoccurring Friday reel. Mm-hmm. Hannah, what is it?
It's Shut the Fuck Up Fridays.
And so if our client had listened to that reel, but here's the problem with that client. He had for years been basically a state witness. Mm-hmm. And had kind of felt like a level of comfort. I mean, no one feels comfortable being a state witness about a murder, but he was like, he was in the fold. Those guys had him on speed dial. And so like when they came up to him years later in California, he just kind of fell right back into that, and then they put him on the polygraph. Mm-hmm. And that was bad. Was that the only false confession case we've ever been forced to put up? False confession is tough.
It's the only one that went to trial. We've had clients that objectively did falsely confess under pressure.
Like what? I know who you're going to talk about.
Well, we had a young client who was like 17, 18, very, not the sharpest tool in the shed, but his neighbor had been really badly, someone entered the sliding door of her home. Actually, it was his friend's mother. And 2 people hit her, sexually assaulted her. It was dark. She didn't get a good look. But they, through the rumor mill, got to his co-defendant, who confessed under some, standard, tough interrogation practices by this particular officer. And he confessed and said that our guy did it too. So when they went to our guy, they used the same tactics and said, your buddy has already told us you did it, which he did. And our guy said things that were wildly inconsistent with the evidence, because that's a hallmark of a false confession, is the guy is just trying to say things again to get him kind of out of that bear trap. But, regarding the sexual assault, whether he used a condom or not, it was totally different than the actual evidence. The whole setup was different, but he ended up saying he did it. And so when I got
Luke, let me ask you a question. Did the fact that he said things that were inconsistent with the evidence that time prevent him from getting charged with a heinous crime?
it did not. If you say you do it, even though what you're saying is really inconsistent with the evidence, you're going to get charged. Or at least he did in this case. So when I first met him, he's like, well, I confessed to home invasion and rape, but I'm innocent, Luke. Help me. And I was like, oh, man, why'd you go and do a thing like that? And so we worked really hard establishing his alibi, investigating the case. And finally, what solved it for us was the DNA evidence came back, and it showed that he was excluded. The suspects definitely left their DNA on this woman, and it also, not only did it exclude him, it matched another guy who had kind of a history of this kind of thing and matched everything else, and he ended up getting, our clients finally got their case dropped, exonerated, and the other guy got prosecuted. Thank goodness for DNA. I mean, he did sit in jail for about 6 months. But it was a prime example of how, the techniques that police can and learn to employ, they will get a confession out of the guilty guys, and that's good objectively for society. But those same techniques also can get a confession out of the innocent folks, because it's that pressure to cough up something that cops want to know. So it can be problematic, and that's a whole other chapter of
Another season.
Right, but this was one of those cases, and thankfully for the DNA and our hard work, that he's out there being his sweet little weird self, and I hope no one ever accuses him of anything ever again, because he might say he did it,
because we know he'll admit it.
It's a people pleasing problem.
But false confessions are not easy, because it's very hard for a juror to sit there and go, I'm putting myself in that client's shoes. Well, I can't ever imagine I would say something like he did if it weren't true.
Well, all jurors feel that way.
Mm-hmm.
All law enforcement can kind of say that same thing too. I mean, some of the best interrogators have such good training and techniques, even without a polygraph. Was he polygraph?
No.
There was this one pretty notorious investigator that would get a lot of confessions. He was on this case. Mm-hmm. Real big guy. He was very good at the read technique and other investigative techniques, and he would get confessions.
What's the read technique? Is it like an acronym, or is it?
Yeah, it is an acronym, but it's just...
It's a whole
I think we could do a whole pod on the read technique.
A lot of it has to do with your positioning, good cop, bad cop, building rapport, intimidation, threats, body language, all that stuff. But it's a technique that they get trained on. So
while in polygraphs are not admissible in court, something we have on very serious cases, we'll do a private polygraph of a client and try to see.
You just did one, right?
We've done a
couple weeks ago.
But if they're good, we will take it to law enforcement that we trust and say, take this down to your polygraph examiner. We've had a couple cases like that resolve themselves because our people will pass them. But they're not court ready. Not court ready.
No.
So someone has requested maybe a lighter story, and I'm remembering one that you guys told about when you guys were working a case and the tale of two jurors that fell in love over the course of the trial. Do you remember that?
Oh, that was...
Talk about the case as well, but also...
That was Barry. Remember? They were like holding hands. So, well, this case, I don't know how light it is. But there was...
But the two jurors that fall in love...
There was a love story. But this was... we were defending a case where it was a pool hall murder. And we were arguing self-defense of a bully. And then as our guy was trying to figure out his next step after the murder, he got in a position where he was forced to defend himself once again with his AR-15 with a number of officers that were trying to bring him in on the charge. And so this was in Edgefield, South Carolina. That's a very kind of rural county, historic county with lots of bloody Edgefield is his nickname, because there's all kinds of bloody things that happened there. But yeah, I mean, Luke, you want to talk about the pool hall and I put this.
I thought we were talking about the jurors.
We are going to talk about it, but I put this under the category of defenses. So we've got ID, we've got self-defense, false confession. I've got a category called "It didn't happen," like S didn't happen, and then I've got one category called "When cops lie." And I would put.
Because cops don't always tell the truth.
And I would put this under the unique kind of subcategory of "It didn't happen" to where cops lie.
Cops lie. It's a cops lie case.
So I'll start it by saying we picked this jury. It was a very lengthy jury selection process. A bunch of strangers, and there were two young people that
strangers at the time.
So after a jury gets seated, we can talk about that process. But for today, they were kind of on opposite ends of the jury box for this week-long trial. And as the days kind of continued on throughout the week, they got closer and closer and closer. And then by the end of it, they came out and they'd obviously bonded over the experience. And as soon as they got out of the courthouse, we were kind of going out through a little different exit. They were like holding hands.
Yeah.
And they were total strangers, but they were holding hands, walking down the square of beautiful Edgefield during Christmas. I remember the Christmas.
Wow, what a Hallmark movie!
Christmas tree was up. The Christmas music was playing in the square.
It was like Groundhog Day.
And these two young people were holding hands and walking to presumably their cars,
finding justice and love at the same time.
But let's talk about the justice. So cops lie. Do sometimes cops lie, Luke?
Why, yes.
Well, why? Let's hear about this cops lying on this case.
Well, I mean, so we have two cases in one that we were forced to try together. One was a shooting at a pool hall on video, which we claimed was self-defense. It was on video, and we lost that part of it. I'll just say that. But the part we won was that an hour later, the police, looking for a shooter and knowing who it was, followed our guy, and the officer in particular, who we feel was untruthful, claimed to have a beat on our guy, and he went down a dirt road, which he did, and the cops following him
Now the two counts were of attempted murder on officers.
Yeah. And so our guy was a little scared. He wanted some time to cool down. And he did go down this dirt road, and he backed his Mercedes into this clearing right off the road. And was like, all right, that's it. I just wanted to, get somewhere safe. I could do this on my own terms, but these guys are coming. So he cracked a fresh Coors Light. What was he drinking?
Coors Light.
And he had these NASCAR sunglasses on.
He had himself a sixer.
Yeah, and he just standing in the apex of his door, like with his arm up.
His Oakleys.
His Oakleys.
Were they white frame Oakleys?
They were
wraparounds.
They were like
sure.
ring, like hypercolor, like reflective wraparounds.
Okay. Those are cool now, I think.
And he's thinking, all right, the gig's up. These guys are gonna stop me, and that's fine. And what police said was that as they came into the clearing, our guy's lying in wait with his AR-15 and just waylaying them as they get into the clearing.
Now, why did he have an AR-15 in his vehicle, Luke?
Well, he had all his guns in his vehicle because he was moving out. That was part of the pool hall conflict. He was breaking up with a girlfriend. It was a source of the conflict. He had all his guns, clothes, safe,
he had
medicine.
He had an arsenal of firearms.
He had a lot of guns.
And a garrote. A garrote.
A garrote, yes.
What's a garrote?
That's that French decapitation, choking wire.
Oh, yeah, we've talked about
We
this.
talked about that.
Yeah.
But, so those cops were telling a naughty lie. And what our guy said was, no, I'm sitting there drinking my beer, knowing that I'm going to surrender.
Friday night.
And all of a sudden, the cop in the lead just starts doing a drive-by shooting on me. And I get shots tearing across his chest. He ducks.
He got shot in the shoulder.
He got shot in the shoulder, and he's like, kind of a good old country boy. And he's like, well, I'm not going to let you hunt me. I will defend myself. So that's when he starts returning fire. And so we had to really figure out what was what in this case.
Is this the reenactment?
This is the whole thing. We've talked about this case before. We
Great video of this gun battle. I mean, it's it's not.
We actually used kind of some behind the scenes footage of those photos on our socials a lot.
I mean, none of it's
We've ever
great,
seen
but it is a gun battle.
Well, long story short is that we were able to prove that the cop was not shot at in a perpendicular fashion as he crossed in front of our client, that he actually did the shooting through sound analysis because he was shooting a .40 caliber Glock. There's a very different sound between a pop of a Glock versus the of an AR-15. So number one, based on sound analysis, he was shot first. Also based on the impact points of trajectory analysis, the cop was shooting very much perpendicular versus where he said after being fired upon, he parked his car and got out and shot. No, it was not at those angles. And the shell casing count was off. That cop shot several times from within his car with those shell casings ejecting inside of his car and not out where he said he would be. So his casing count was off. His mag count was off. And the funniest part was this cop was like about 6'3", about 280. He really filled up the kind of front.
Oh, he was a big boy.
The driver's seat. Like you're not. And so he claimed, because we had a bullet from our client in self-defense go through the frame of the B pillar behind him, and it ended up in his steering, like right in the middle of his horn in his steering wheel. So if you're this big old boy, it would have cut right through you. This cop was never hit. So he tried to say that only by the grace of God, as he drove by our client. And I was like, so I had to bring up his size and discuss and get him to agree.
He was not defensive about that.
How he filled up that vehicle. And so what I was showing was that he was out of his car, parked, and behind it when that bullet hit. Otherwise, it would have just cut him in half. And I think I said something like, "You must have been made of fresh air," or something like that.
Well, I just remember, like, the problem with this whole second crime scene was that the officer. So what we established through science was that these officers did a drive-by shooting on our guy.
Right.
It was scientifically proven, and they were all like, "Oh no, man, we would never do that. And we'd never do that." But like, this was a rural town police department. And when they were at this crime scene where everyone, literally, the chief investigating officer, Listink, was the ex-husband of our client's then girlfriend, who was the cousin of the guy, the victim, the bully at the pool hall. And so that's like, and so they're all sitting around investigating the situation, and then like it comes over the radio that like the guy, he's driving down a dirt road, and they're all like freaking out, and so all these cops go running from the pool hall, and we got their body cams, and they're all like diving into patrol cars, like this is like the best thing that's ever happened. This
Well, of course, the bad cop who did the shooting, his body cam, he did not have one that day.
Oops.
So we conveniently couldn't see any shooting coming from his car.
But like these officers were so
Jazz.
Like this one guy, his body cam, he had AC/DC playing in the car, like
Thunderstruck,
and he was like driving around, and cops are driving with like they're working their radios, they got their shotguns like up on their laps, like literally like driving with their shotguns like in one knee. This one officer,
he was listening to the radio, the police scanner, just in his couch, shifts over, drinking a cold one, and just leapt up in that.
Like so part of our job at this trial was to show how poorly trained these officers are. Like one of the cops had a criminal record.
And he was impersonating a police officer
before he ever became a cop. So like it was just poor training. But I like to think that the love from those two young folks.
I was wondering how we're going to tie this back in.
The bonding, the longingly romantic stares in that jury assembly room would have said, all right, we can believe what these people are telling us because anything's possible. We found love back
We
here.
found love
So,
in
like,
the jury.
these defense lawyers are saying that we should not believe these officers when they're saying that they didn't do a drive-by shooting. That we should believe the science. Okay, because I'm feeling magic happen right here. Back
This
there.
is chemistry right now.
So, like, anything's possible. We believe in the science, and so.
And so you guys had a successful outcome with that?
So yeah, not guilty on the attempted murders on the officers, which honestly is pretty difficult to accomplish.
Yeah, I would imagine. You guys have had quite a few.
And then they were guilty of love in the
Guilty of love.
back.
There you go. I'll make sure to really emphasize that when I edit this pod. You guys have had quite a few cases in which cops were victims, or yeah.
Yeah, we've had a couple death penalty cases where it's obviously not laughing, not light. Where
It's not like teachers falling in love.
Right, yeah. Police officers get shot and killed, and that makes you death penalty eligible in South Carolina. So nothing funny about those, but very serious, and we were able to resolve both of those with life sentences. So that was good for our client, but just very tough stuff. So one of the most light-hearted, if anybody's looking for funniest cases, were it was a robbery of a post office. And the case comes to me as a young public defender, and they've got my guy arrested where he's supposed to have jumped, like you're waiting in line at the post office and you jump the front counter basically where the people keep the stamps and their money. The money was gotten, and this description was a young man with dreadlock hair between 20 and 25 years old that actually had an FBI sketch artist who then was being chased by a postman and ran like 300 yards away through this apartment complex that was behind the post office.
I was always really impressed with the postman. He was getting after it.
He was booking it.
And he was going to get that money.
He was chasing, but he wasn't fast enough because obviously the young man, who was between 20 and 25 allegedly, is quick.
I feel like we're going to get to this.
But they found a wig in the bushes on the path of flight, and so they tested this wig.
What color was the wig?
It was purple.
A purple wig.
Wait, I thought the person had dreads.
Well,
why are we testing random wigs?
That's a good question in the first place. But the description was a young man with dreads. One witness said it almost was like he was wearing a mask with streamers, kind of like a bicycle streamers.
Like old Greg?
So we had a couple different descriptions, but they got a DNA hit from this wig, and lo and behold, it comes back to my client at the time who had just got out on parole for bank robbery and previously basically, let's just say this, he spent most of his adult life in prison, but he was bald. He was completely bald.
No dread.
How old was he?
And in his 50s.
Ooh, wow.
So
Not
very,
20 or
very
25.
inconsistent with the allegation, but we had this DNA problem to deal with. So now I ran into this client the other day on the street, and he's doing quite well, and we had a little moment. And he's working at one of my favorite restaurants in the kitchen, but the trial was really tough for him, and so he basically said, "Look, I didn't do this, but I'm like, well, what are we going to do about this DNA in this wig? I mean, how are we going to?" He says, "Look, I don't know about that, but I will say that, I used to live there with my grandmother, right there. Those apartments behind that post office. And, I spent a lot of time in prison, and it kind of makes you see different about romance and relationships. And I like everybody, girls, boys. And, when I got out of prison, I would like to feel sexy. And sometimes I'd put on my grandma's purple wig. And I would go out.
As one does.
When
they're needing a little
I
boost.
felt sexy, and I would go to the clubs and just feel good about myself. I was like, all right. And he's like, now that apartment, about a month prior to this post office robbery, it burned down. And I was like, I'm going to be able to get some records of that? And he's like, yep. So I found records, and he's like, the fire department came, they hosed it down, the place was totaled, the people just were picking through. And a lot of our belongings were out there, and I think that wig was just out there as kind of like wreckage of the fire. And so he testified to that very thing to explain why his DNA was on the wig. That it wasn't because he put it on as a disguise to do a post office robbery, but because he liked to be sexy and pretty and feel good. And he also had an alibi. And so we're like, what's your alibi? He goes, yeah, I'm hanging out with Gerald under the bridge, drinking. I drink there every Tuesday. And we're like, really? So we found this old guy. Gerald.
Now, Gerald's house was actually under a bridge.
Well, it was right next to the bridge.
Right.
And so they would hang out there. And there was a really funny cross-examination where the prosecutor was trying her best to get our alibi witness to crack. And he was just grumpy old guy who said, yeah, I had a scheduled drinking appointment with your client on X day during the robbery. And she's like, oh yeah, well, what were you talking about? And and this was like 2 years prior. And I'll never forget, he goes, I don't know what I was talking about. Telling lies, man talk. So, just talking about telling lies, man talk. And of course, it got the whole courtroom to laugh. And he was like, what were you doing 2 years ago? And she had no response for that. And it was a hung jury. So the jury couldn't make up their minds. And ultimately, after that, we got a deal to make the case go away. But it was wild. It was kind of wild. It had it all. Alibi, ID, sexy wigs. Meanwhile, the whole time, though, like, the funny thing about our client who was in his 50s, he would, one of our main defenses was that, like, well, you're old. The eyewitness thought this person was 20, at best 25. Someone extremely athletic who vaulted this counter and hauled butt.
And the fit postal worker who came in to testify, was in shape.
Right. And so, but for whatever reason, our client liked to brag to us about how when he was in prison all those years that he was on the prison boxing team and he had all these like welterweight championships and like he was also on the track team.
Aging like fine wine.
And he was a long distance runner and he really did have this perfectly young face because he's like, he's not spending a lot of time outside. He's,
it's pristine.
So I'm like, don't tell us
He was probably also using grandma's lotion.
Yeah.
So we're like, we don't need to hear about how fast and young you look. But anyway, that was a wild one. But I saw him the other day. He's doing well. He's on the straight and narrow. Everything's good.
That's great.
So
Nice.
Y'all have quite a few alibi cases. Are there any other like notable ones that you guys kind of want to touch on today?
Well,
Was Sherman alibi? Or one of his?
Sherman is a client that we've successfully won 2 murder cases of his. And he was there on both occasions. The first one was just like a bad drug situation, drug deal, that he went with his friend to this house to get some weed, and then the guy that was selling and his friend that was buying just got absolutely sideways with each other for no reason, like locked eyes, and like, you looking at me funny? What you looking at? It was like one of those things that was weird, and they just both started drawing their guns, and Sherman's like, oh, what? And so I remember Sherman was just like, as soon as I saw those guns, I was out the door.
Oh, that's right.
And so technically he was there, but when the shots got fired, he was like 2 blocks down the street. We did have an alibi case one time where our client was the drug dealer for a girl that got killed and strangled, and her apartment was set on fire. And he's on video, like right before, and then we were trying to assert that he was long gone. This was a crazy case where the victim is telling people that a member of law enforcement that night was coming to kill her. And so not only was it an alibi defense where we were saying our guy was there and then left, and then let's say 20-30 minutes later someone else comes and does the killing, but we had a lot of witnesses that were saying that the victim is saying that this guy who's a cop is going to come and kill me for various reasons. And so we had a couple of witnesses that were kind of speaking the victim's truth from the grave about that issue. It was supposed to be about an affair that was going on where she was, having this relationship with this officer who was married, and she was going to out him unless he left his wife. So that was kind of the situation, and really, and this was a long time ago, but when we were living this case and defending this case, it really almost felt like, the movie Training Day, because, this particular officer, owned that complex, was a narc, everybody knew about this guy. And so, but right before the killing and before the whole apartment got set on fire, this cop car shows up. There had been no 911 calls, no calls for service, but the video was so bad that you can't see who's getting out. We just know a cop car shows up right in front of the apartment, and then shortly after, the whole place goes up in a blaze, and then we have these two witnesses saying that this guy was coming to kill me that night. And our guy was just the last guy on the scene, and he was just yeah, I gave her some drugs and I left. That was a real tough case because, we did have to call the officer as a witness, and this was a third-party guilt case. So it was an alibi case and a third-party guilt case. So our alibi was basically, trying to suggest he was back at his own house at the time the killing happened through but the problem was he lived in the apartment complex. So we did cell phone triangulation that wasn't a whole lot of help because he was basically in the apartment complex. And then we had some alibi witnesses that kind of were able to help establish that he generally was back at his apartment around that time, but they weren't the best witnesses. But I think the thing that hurt us the most on that case, is incredibly difficult, even with witnesses that are saying a cop is coming to kill the victim that night. Her rape kit also went missing. It was checked out by law enforcement for no legitimate reason, and then returned in a way that no one could even tell if it was actually her rape kit. So that was a big issue. The autopsy of the victim, they always check certain things, checking someone's uterus is very standard on an autopsy, along with rape kit and everything else. All that was not done in this case, inexplicably by the pathologist, and our whole theory was, she's pregnant, and that would lead to questions about, who's the father of the child. This was also a case where she was killed with her own bathrobe
tie,
and so the question became, where's the bedding in this case? The bedding was missing, but these other officers that were with the same agency. We're basically saying they found bedding in the dumpster, and they kind of brought it. The officer that actually was our suspect showed up to the homicide investigators with this bedding and said, "Oh, hey guys, this is my block. I'm the narc on this complex. I found some bedding in this dumpster." And we had video footage that the dumpster had already been completely emptied by the dump truck earlier that morning.
So how had the bedding been there?
So, we had eyes all over that. So it was a crazy case. But the best thing for the state was they had a weak, but albeit kind of in the zone DNA hit for our client on the ligature of the bathrobe, the tie that was used to kill the victim. Now our client, and so the expert was basically able to say, yeah, it's either a client with your kind of chromosomes or someone a male in his family could be a source of this DNA. And our client's male relative, his uncle, actually had serviced the victim's bathroom that week.
He was a janitor.
He was a janitor.
Apartment.
Where a bathrobe would have been hanging. So, the biggest thing was in that case, we had a federal snitch come through the jail. A likable guy, a character. And he was coming through county jail to serving a federal sentence to tie up some loose ends, some state charges he had. And he took one look at our guy and started talking to him about, what are they trying to say? And he said our guy totally confessed to him about, certain details that you could really only get either from discovery, from the evidence. And he got up there and basically said, yeah, this guy confessed to me. And so that was really problematic for our case. But that was a wild case because we had to call this officer to the stand, and he had gotten a promotion from a time before the trial to in the middle of the trial. He had been elevated a couple ranks, and that was interesting. And then we had to Mirandize him on the stand, which was quite interesting for a member of law enforcement. But our guy, it was hard to overcome that information. But that was alibi and third-party guilt of an officer, which is very interesting. But yeah, that case had me. I remember I was like scared to go to sleep at night, thinking like anytime I see a cop car coming down my street, I was.
Well, that's when I started carrying a gun all the time.
Yeah. You start making
And a garrote when you need it.
and a garrote.
Keep a garrote on you at all times.
But yeah.
Well, I know that y'all can do this for hours.
Yeah, we can tell some stories.
So there's plenty more stories. So if you guys have any questions for these guys, feel free to reach out to us on our social media pages. We would love for our listeners to go and leave us a Google review and mention to Bring the Jury the podcast. That would be fantastic. Just Google the Sheely Law Firm and you can do that. But yeah, we're going to wrap it up for today. We are celebrating our season finale. We began at the beginning of the year talking about the Alec Murdaugh trial and have kind of just kept this journey going. But we are wrapping up today. We're going to take a 3-week break, and then we're going to return again on Monday, July 17th. So go ahead and mark your calendars, subscribe to this channel, follow, all that good stuff so you don't miss it. We'll be back. Feel free to reach out to us with any cases that you would like us to talk about, or we can keep telling more stories. As always, you can follow us on Instagram, TikTok, Facebook, Twitter, LinkedIn, YouTube, all the things. This episode the full episode will be posted and shared on streaming platforms and YouTube. If you missed any parts of it and you would like to go check out the full thing, please feel free to do that. Like, subscribe, review. And yeah, this has been Bring the Jury, Season 1.
Bring the jury.
Bring the jury.